Oh, here we go.
There we
Hey,
go.
Jerry, how's it going, my friend?
Good. How are you?
Yeah, fantastic. Thanks for joining us to give us another update on Making a Murderer and answer some further questions.
Sure.
And off the top, then, we've got something's happened with Zelna yesterday.
Yeah, it was a bit of a false alarm. I think tomorrow is the actual reply to the state's response. Yesterday, she filed a document which essentially tried to clear up some citations to the record mistakes. This is a very old case, goes back to 2005, long before there was electronic filing and scanning of the documents into the record. And I've seen this in other cases as well. Apparently, there were some mix-ups in which documents were, assigned to which document numbers. The state pointed that out in their response, and then she filed a request to amend her motion that corrected those citations, and that's what she did yesterday, is actually file that amendment.
I mean, how long can this go on for?
It can go on, unfortunately, a very long time, as people are learning. I had a case where a guy named Ralph Armstrong that I was working on for the Innocence Project that was fighting for 19 years, actually 15 years with me, before we finally got him out. So, that's one of the problems with American justice, is just it takes forever.
And it's one of the reasons, perhaps, the people who originally put them in prison, they have moved on, and it's a new breed of people re-examining these cases.
Well, are you talking about the prosecution, or there are new prosecutors on the case. Everybody else has retired. Although, if he gets the case reversed and it's brought back for a new trial, one or more of those prosecutors will probably be appointed to represent the state as a special prosecutor. They'll come out of retirement, so to speak.
Wow, which one would that be?
I would not be surprised to see Norm Gahn come back into it. I don't know about Tom Fallon. He certainly could. Mark Williams is already being a special prosecutor in other counties and other cases, even though he's no longer actually appointed on this one because it's been taken over by the AGs.
So what is the different status of the cases of Stephen versus Brendan right now?
Brendan's case is actually dormant. He doesn't have a motion pending in court. He went all the way through his direct appeal through the state courts. He then filed the federal habeas corpus, went all the way through the federal courts. In fact, all the way up to the United States Supreme Court, that then chose not to hear his case. And so his direct appeal was completed. He could still file what's called a collateral, we call it 97406 motion, if there's newly discovered evidence or something of that nature that comes up. But right now, that has not yet been filed. Right now, his case has moved to the executive branch. He requested the governor to grant clemency, not necessarily a full pardon, but the governor is authorized to shorten sentences and release people early. This particular governor has not exercised that right yet on any case. And about a year ago, Dean Strang and I wrote a letter to him that became public, where we were actually urging him to take this case as the very first one that he reviews, and then to use that clemency power with many other cases, because the way he has done pardons, he has issued pardons, but his rules for that are that you have to be out of prison and off supervision for a minimum of 5 years before you can apply. So that does nothing to reduce prison overcrowding and all the people that are languishing in prison now on the kind of uber long sentences that were being handed out in the 90s, 80s, 90s, and 2010s. So, I'm sure that Brendan's lawyers are still working to see if they can convince the governor to take another look at his case. He really should. There's people on social media every day that are asking the governor to do that. And but at this point, that's his option. There is no other case pending, no other motion pending in an actual court.
What's the governor's name so we can get some more people on his case?
Tony Evers, Evers.
Right, well, people will find him on Twitter, no doubt.
Yep.
I mean, it's an absolute tragedy. How does a kid cajoled into a confession where there's no DNA evidence whatsoever end up stuck in the system for this long? It's barbaric.
You know, it is barbaric, and frankly, one reason he stuck this long is because of you see it in season 2 of Making a Murderer. They look at what's called the EDPA, which is this this law that Congress passed in the 1990s during the height of the war on drugs and the war on crime, and basically it's called the Anti-Terrorism and Effective Death Penalty Act, EDPA. AEDPA, and it came about for 2 reasons. One, because of the Oklahoma City bombing, and the Sean McVeigh, and then the World Trade Center first bombing in 1993, and in part, and probably in large part, because of very clever death penalty lawyers, good advocates who were managing to drag out the ultimate execution dates for people by filing motion after motion after motion in federal court, asking the federal courts to re-examine these state convictions. And so Congress, particularly some in the South that had death penalty states, really pushed Congress to change and make it more difficult for federal courts to review and reverse a state court. And that was really the impetus, along with the Oklahoma City bombing and some other terrorist type things, that caused that law to be passed. Clinton signed it, and it has made it much, much more difficult. Less than 1% of state court convictions get reversed now in federal court. And so even though Brendan came very, very close, he convinced essentially four federal judges that his confession was coerced and it should have been thrown out and he should get a new trial. Ultimately, on an en banc review, he lost in a 4-3 very close decision.
Oh, that's terrible. We've got an observation from one of the viewers here. We'll see if we can get you to comment on. Sean, not only was there no DNA evidence, Brendan had no representation during the interrogations. Is that legal, what they did?
It is in Wisconsin. In fact, in some of the states have changed their laws now after Making a Murderer came out. And they actually, Illinois, I don't know if Tennessee has done it yet. There was talk about it. A number of other cities, Seattle and some places, that have barred any interrogation of children 15 or under. It varies from one jurisdiction to the next, and then actually that wouldn't have helped Brendan because he was 16. But in those states, they're recognizing that the Reed technique that was so well demonstrated in Making a Murderer as being used against Brendan, it's really unfair for young people with vulnerable, even vulnerable adults, going up against these very skilled detectives. And so in those states that have changed the law, the police cannot even take a waiver. That is, that no matter what the child or the vulnerable person says about waiving his rights, they cannot do it. They have to have a lawyer present. And of course, as we also see in Making a Murderer, the quality of lawyers varies quite a bit. If Brendan had Lynn Kaczynski, for instance, his first lawyer, present during the interrogation, would he have cooperated and gone ahead and allowed them to do that? I don't know. He certainly did. 2 interviews later, he allowed his client to be interviewed even without him being present. So, but it is permissible in America, and unless this is the rule, unless the suspect, him or herself, unambiguously demands a lawyer and exercises their right to remain silent.
Are there laws or rules about parents being present?
There are some, again, it varies from jurisdiction to jurisdiction. There are some laws that require parents to be notified, but not necessarily that they be present. So in this case, for instance, in Brendan's case, the cops claimed that they contacted his mother, and that they then went ahead and took him out of class and took him into this private interrogation. But parents are not allowed to be present in the interrogation room with the officers in almost any jurisdiction that I'm aware of.
Okay. Looking more at the Avery's situation then and KZ, the main point of contention will be whether an evidentiary hearing should be held. In your opinion, Avery is being held to a much higher burden to even get a hearing than any other defendant you have seen in 40 years of practice. Why is that then?
Some people have said, has making a murderer actually made it harder for Stephen to get justice because they've circled the wagons and they're afraid with all the global following of what happens now in the Wisconsin court that it's and that may be true. For instance, I think in this particular judge's case, she knows that if she grants a hearing, there's going to be, the media is going to descend upon little Sheboygan County because that's where the case has been farmed out to, and that she would be under the spotlight. And, that's not going to be an easy situation for any judge to face. That might be part of the reluctance, shall we say, to grant a hearing in Stephen's case. But certainly from the state standpoint, they don't want to have to relitigate this with actual witnesses. They want, in fact, I think in their response, they really misled the court on a lot of what the facts are. And they don't want to have those facts, the real true facts, aired in public, in front of cameras, in front of the judge again. They would rather stick with the way that they can sort of spin the facts that have already been part of the record and spin them the way they want on paper rather than have actual live witnesses. Now, on the other hand, if Making a Murder hadn't come out and nobody had ever heard of Stephen Avery, he probably would just be rotting away in prison like thousands of other people. So, it cuts both ways. He's gotten the kind of attention that many people haven't, but that may have hurt him in other ways, like his ability to get an actual hearing to try and demonstrate that the evidence is really a shaky house of cards. It's about to fall.
So when you talk about the narrative then, is that the narrative that was first established by Ken Kratz?
A lot of it, yeah. I mean, the states kind of cuts it both ways. They don't want to, for Brendan's case, of course, they wanted to use that narrative, even though the evidence disproved it. There was no blood that would corroborate this kind of, bloody stabbing and the slitting of the throats and all of that they say Brendan said, when actually he was kind of guessing and they were feeding him facts to try and make a story fit. But of course, in Stephen's case, at the trial, they didn't use Brendan's actual confession. And so now in their response, I had to kind of laugh at this. In their response opposing a hearing now, one of the things, again, it's this Denny motion is coming up again because Kathleen Zellner wants to point the finger at another named suspect, that is Bobby. And in doing that implicates the Denny rule, which is, was there motive, opportunity, access, connection to the murder or to the crime? And what they want to try and argue, one of the things that Zellner has argued is, look, there's this computer analysis of the Dassey household computer that she says shows these searches that were during a time when only Bobby was home, and they involve essentially torture, murder, porn, young women about the same age being mutilated and tortured. And in their response, in the state's response, because that of course is the version that Ken Kratz gave to the world in his press conferences before trial, polluting the entire jury pool everywhere. But in the state's most recent response, they argue, well, that's not enough because no one's said, there wasn't any evidence in Stephen's trial that Teresa Halbach was mutilated or raped. In fact, they dismissed those charges. They charged him with it, but they could never prove it, so they dismissed it. Now, because they dismissed those charges, they're trying to double speak and argue, hey, this doesn't prove motive because there's no direct evidence that he was looking for people who were shot in the head or who were, bodies burned and all that.
Just to clarify the viewers then, who is Bobby in relation to Brendan Dassey?
His brother.
Okay. All right. So
and he was, by the way, he was the star witness for the state. I mean, he's the guy that said that he saw Teresa drive up, saw her talking with Steve, and that he then goes in to take a shower so he can go hunting, and that he watches her walking off towards Stephen's trailer residence front door, and then that's the last he ever saw her. So he's like the last person that they offered, the last person to see her alive, and to which I responded in my closing argument, yeah, because he was a killer. But then they objected and said, hey, the judge precluded us from pointing the finger at him as a possible suspect. So, and that's true, the judge, because we didn't have the sort of motive that Zellner now has, which is all of these computer searches that show his sort of obsession with this kind of murder, torture, porn involving young women.
How convenient the suspect becomes the star witness. So what are the specious arguments the state has raised to oppose Kathleen Zellner's August motion?
Well, they basically, I wonder sometimes if they think that the new judge or current judge that's hearing the motion is just not aware of the facts that were presented, but they're trotting out a lot of the same arguments that they raised at trial and that we responded to even at trial. So, for instance, they say that what about Avery's DNA on the hood latch? How did Bobby plant that? And in fact, at trial, we demonstrated through their own witnesses that might have been an innocent transfer by their own crime lab analyst who admitted he was inside the vehicle sampling, and therefore in an area where we know Stephen's blood was, however it was planted, and that he never changed gloves. He decided, I need to find out what the mileage is, and the battery's been disconnected, as it always is when it's towed in. And so he gets out of the car, goes to open the hood, and had not changed gloves. So we know now with DNA is so sensitive that the potential of transferring it from one location to the next is very risky. And in fact, that's why the protocol is you change gloves. And this guy admitted he made a mistake. So that was one explanation offered at trial. Kathleen Zellner has raised additional alternative arguments. There's apparently a missing swab that was taken from Stephen at one point that might have been used to plant if the police officers were the ones that planted it. So again, all of that was raised in the past, and the state wants to trot this out as somehow inconsistent with the argument that Bobby might be a reasonable third-party suspect. They also made an argument in their motion, a response about how fragments of bones from virtually every part of the human skeleton were found in Stephen's burn pit, and somehow that is more incriminating for Stephen than anybody else. But we also proved at trial that there was also bones from all over the skeleton, human skeleton, found in this burn barrel that was, surprise, surprise, behind Bobby Dassey's house, about 150 yards away. And our argument then, and probably still the best argument, is that her body was burned somewhere else, and one of these burn barrels was used to scoop up the cremains and dump onto Stephen Avery's burn pit in order to frame him. But unbeknownst to this individual who was doing this, some of the bones were stuck in the muck at the bottom of this burn barrel. They're left open in the element. The rain comes in. There's like muddy ash at the bottom, and so therefore it was jumbled up. In other words, there's a jumbled mix of various parts of a skeleton in the burn pit, just like there is a jumbled mix of various parts of the skeleton in the burn barrel. So the argument that, oh, we found fragments from all over the skeleton means it must have, in the burn pit, means that's where she must have been burned is totally specious. Plus, they never found, I can't remember if it was 60% or 40% of her entire cremains were ever found. The rest were never found. To this day have never been found. Or if they were found, they were part of these quarry bones that, unbeknownst to us and unbeknownst to his appellate lawyers, were then given back to the Halbach family without court authority while the appeal was pending, and then were disposed of. So at any rate, nowhere near all of her body was ever recovered in Stephen Avery's burn pit.
There was a bullet with Halbach's DNA found in Bobby's garage.
Yeah, now that was another argument they made is, hey, how does the fact that Bobby could be a suspect explain this bullet with her DNA that was found in the Avery garage? But the problem with that was, we showed, first of all, that bullet was not ever even recovered by the cops until 5 months after the first week-long thorough search of the garage. Somehow it magically appeared 5 months later when it wasn't there before. And we showed at trial that the test of that bullet was contaminated by the crime lab analyst herself. And so normally the test should have been thrown out. Never in her 30-some year career at that time had she ever deviated from the protocol, which says you throw the test out if there's contamination. So they really had to twist things to even allow that evidence, that opinion to come in, that it was her DNA on the bullet. So it very well may have been, again, innocently planted, or innocently planted on that bullet through contamination at the crime lab. Again, Kathleen Zellner has raised other arguments as well. So that is by no means proof of why Bobby couldn't have been involved in this case.
So how realistic is it then that these guys are going to get some mercy from the justice system, as opposed to remaining buried alive?
Well, they have two different public, I guess, perceptions. I think Brendan's, frankly, is more sympathetic with most people, because most people that look at that case really think he had nothing to do with it. There was no evidence linking him to it, frankly, other than his confession, which was highly suspect and really the hallmark of the kind of techniques that produce false confessions. So his is, I think, a more sympathetic picture than maybe Stephen's. Some people, it's maybe 50-50. They think, well, there is at least circumstantial evidence that was found that links Avery, like his blood, in the RAV4. Now, was it planted? That's another issue, of course. If it was planted, then you have to ask yourself why. Just like the key that was found in his bedroom also planted. If they went to those kinds of lengths, why? Who's to say they wouldn't have planted the blood as well? But at any rate, a lot of people, I think, agree that he should get a new trial. It wasn't fair. If the state thinks their case is so strong, let's just air it out now. Let's present everything that they hid from us in the first place, because there's a lot of evidence that's come out in the last 10 years or so that was not disclosed to either us or his original appellate attorneys. So, but there is this, it's very, very difficult. There's this doctrine of finality in America where they really do everything. They bend over backwards to keep from reversing convictions, even in cases where there's evidence of corruption or incompetence, crime lab scandals. There's a case right now in Texas, a guy named Escobar, whose DNA evidence was so screwed up in this crime lab that even the prosecutor stipulated that he should get a new trial. But in Texas, and then the judge agreed, the trial level judge agreed. But the state, that then has to be reviewed by a higher court in Texas. And the Texas High Court reversed that, reinstated his death penalty conviction, even though the state and defense had agreed that he should get a new trial. It's only because recently the United States Supreme Court reversed that decision and sent it back to Texas that this poor guy may have a chance. So, it is very, very hard to get convictions reversed in America. It's not impossible. There are cases where it happens, and I'm still hopeful that it's going to happen for both of these guys. But it is taken a long time.
Do you know the present status of Ken Kratz, Kaczynski, and was it Brad Schimmel?
Brad Schimmel is a judge in Waukesha County near Milwaukee. He was the attorney general, and then he lost his re-election to that particular position, and then the outgoing governor, who also lost, appointed him as judge in Waukesha County, and that's where he's been ever since. Kaczynski was also a judge, but a municipal judge, which is much less serious cases, really just traffic ticket kinds of things where you can find people, not send them to jail. He got into his own problem of involving a harassment of a clerk. He got charged. He was ultimately acquitted of most of the counts, the felony counts, but he was suspended. His ability to be a judge was suspended. So Kratz, meanwhile, has kind of dropped off the face of the earth. Last I heard was that he may be in Las Vegas. I'm not sure exactly doing what, but he is no longer practicing law in Wisconsin.
Wow. Okay, so in general then, American cases, the appeal, it's just astronomical how long it takes, isn't it?
It is. In some cases, we do have procedures in America where you can get your case brought back, vehicles that defense attorneys can raise, motions that can be filed that you don't have in some cases or in some countries. Australia, for instance, if there's evidence of innocence after your whole direct appeal is completed, the only way you can get back into court, I believe, is by persuading the attorney general to make a motion to do that. And that really doesn't happen all that often either, of course. But so even though there are vehicles in America for getting your case back into court, when it comes to actually getting reversed, it's very, very hard.
What's with the prevalence of bogus junk science being used in court?
That's my entire career has been a pet peeve of mine. That's why I, along with Dean Strang and Keith Finley, we founded a nonprofit based in Madison, Wisconsin, the Center for Integrity on Forensic Science, which focuses exclusively on trying to improve and reform the forensic justice or forensic evidence used in our courts. Unfortunately, it's not getting any less used. There are certain types of evidence that are being used less and less. So, for instance, 20 years ago, 30 years ago, 40 years ago, microscopic hair comparison evidence was commonplace. Thousands of people were convicted of it. And the idea of it was, if we find a piece of hair at the crime scene or on maybe a victim's body, and then there's a suspect arrested, we, pluck a reference hair from his or her head and you look at under a double field microscope, and these so-called experts were then giving their opinions about whether the hairs were consistent with each other. And prosecutors routinely overstated that. And either the experts themselves would overstate what the science could prove, or the prosecutors in their closing argument overstated it, talked about, these hairs match, when in fact that's not what the science ever showed. And in 2015, the FBI, to their credit, they went back and they looked at randomly, I think it was 268 cases where their own analysts, who would be the best and the brightest, trained in Langley, were testifying under this microscopic hair comparison evidence, and they found that 95% of them either falsely or misleadingly overstated the strength of what the evidence was and what their opinions could be. And as a result, the FBI no longer uses that science at all. Unfortunately, something like 95% of criminal cases in America are done at the state level, and hair comparison is still used all over the place. Bite mark evidence is another thing. Bite mark evidence is completely bogus. Study after study has shown that, and yet it's still being used in many state courts to convict people. Ballistics is another thing. Ballistics is nowhere near as conclusive as you see on television. And as you might think, that you can somehow prove that a particular bullet was fired from a particular gun to the exclusion of every other gun in the world, which is not true. It has never been true. And it certainly is not true today, where guns are mass produced, barrels are bored to perfection, machined, and every one that comes off the assembly line is the same as the next. So, I think part of why this evidence, it's not only that it comes in, it's also that it is so powerful to jurors. And that's probably partly the media's fault, because it's been portrayed in television shows like NCIS or Bones or, those kinds of television shows that of course are trying to wrap up their whole plot within 1 hour. And so that they get this evidence and they send it off to their lab, and it's conclusive evidence of guilt. And that's never been the case. And in fact, DNA, the one gold standard, is even less probative now than it used to be. It's ironic, because the better the science has gotten, the less valuable the evidence has proven to be in a particular case of proving guilt. Because it used to be that you would need a lot of DNA in order to, get a profile that could match somebody. Lots of blood, lots of semen. And if you found that, then it was pretty damning evidence, inculpatory evidence of guilt. How's this guy's blood or how's this guy's semen there? But now the tests are so sensitive that just a few cells, you can pick up a full DNA profile. That touch DNA, innocent transfer DNA, where I shake your hand, you go off and rob a bank and leave a gun, and my DNA is on that gun because I shook your hand. And so the presence of DNA has actually become less conclusive of guilt than it used to be. So this is a problem. It's a problem that I think we need to educate jurors on a case-by-case basis. And what we're trying to do at sifsjustice.org, you can see the link down below, is to try and weed out that evidence that's just so bogus that jurors should never even hear it. And then hopefully it's up to the attorneys to try and persuade the court and the jury as to, with evidence that's not reliable, explain why.
What about the Reed technique? Has that been canned?
It has been severely weakened because the number 2 in America, the number 2 police training outfit, has abandoned it. They refuse to train officers in that technique anymore because they have concluded, and studies have shown, that it does get guilty people to confess, but it has a high incidence, at least too risky high incidence of false confessions that we know through DNA exonerations the suspect was falsely confessing, and then later DNA proved that. So it's gotten weakened. It's still kicking around there though, and it's kind of on a case-by-case basis where lawyers have to learn, how the technique is done, where its weaknesses are, and present that to a court, and then ultimately, if the court allows it, then to the jury to explain to them why it's not reliable.
Looks like we just got a couple of viewer questions before we finish. Ray J's asked, is Wisconsin unique in this type of controversial case, or has this and Rittenhouse case highlighted Wisconsin?
Wisconsin justice or lack of it. Wisconsin has had its share of strange cases, let's face it. The Jeffrey Dahmer, Rittenhouse, Avery, Dassey cases. Even before that, the Alfred Hitchcock movie Psycho was based on an actual case in Wisconsin. And there are many more, but it's also, we are a very big country, approaching 350 million people in America now. And you can find these kinds of cases everywhere. You find some outrageous, unbelievable ones. There's one going on now in South Carolina involving a lawyer whose father, grandfather, and great-grandfather were elected over and over and over as district attorneys in a small county in South Carolina. Well, now he's being charged with the murder of his wife and son, and with trying to hire somebody to kill himself so that his surviving son could get the life insurance policy. A bizarre story that is a Hollywood script. And so, you see these kinds of cases in lots of different places. The UK's had some strange ones as well. But we are, obviously a very big country, and we've got a lot of guns, and there's lots of different ways that Americans have figured out that they can kill people, unfortunately.
Next question. Was D.A. Binger involved in the Avery case?
I think he means, that's a misspelling. I think he means the DA that was in the Rittenhouse case, and no, he was not involved in Avery's case or Dassey's.
All right, Jerry, do you want to tell the viewers then, a bit about your book and where they can find it?
Yeah, my book's called Illusion of Justice, Inside of Making a Murder in America's Broken System. You can find it on Amazon UK, lots of different Amazons all over the world, but also directly from the publisher, HarperCollins. You can find it in libraries all over the place, something like 1,000 different libraries from Perth to Stockholm. So it talks not just about the Stephen Avery and Brendan Dassey cases, but also about similar types of issues that I've seen throughout my career, cases I've worked on. And then it's got some suggestions on what the individual can do to try and help improve the system of justice in their own community.
Since you've been saying that, I've just noticed a couple more questions have come in.
Okay.
Was a search warrant issued for Bobby's property?
No, there was, interestingly, one of the things that I meant to mention earlier in the state's response to Zellner's latest motion was that this bullet, for instance, that this bullet that was found in the garage supposedly with Teresa's DNA on it, came from the gun that was found in Stephen's bedroom, which oddly enough was hanging above his bed, and it had a little piece of masking tape that said Steve's, as if, so we want to make sure that you realize this was his gun, when in fact it wasn't his gun. It was the owner's gun. The owner of the trailer that he was renting. But anyway, they tried to argue in this motion and at trial that this bullet had to have come from that gun and no other gun, when in fact that isn't the truth. That gun was a .22 Glenfield Marlin rifle. It is the most common gun made in the world, millions of them, and the very same make and model was found in Bobby Dassey's house, the very same one, and it was never tested. It was never really compared, to see whether that might have been the source of that bullet. So there was also a deer that supposedly was roadkill that was hanging in the garage that they never tested the blood in the garage where Bobby Dassey lived, which was right next door to Stevens, to see whether maybe Teresa's DNA might have been found in that garage. So, they did see some things from that residence, but they did not do the kind of thorough search that they did in Stephen Avery's.
Last question then is whether the Innocence Project is involved with these guys.
The Innocence Project is not involved with either one of them. There was a conflict. They were involved. The Innocence Project in Wisconsin was involved in Stevens' first case where he was exonerated, the 1985 one. But they have not been involved directly in either one of their cases since. They could not be involved in Brendan's case because of conflicts of interest. But instead, the Northwestern Center on Wrongful Conviction Involving Youth at that time took over Brendan's case. Two very good lawyers, Laura Nyrider and Steve Drizzen, represented Brendan, but the quote-unquote Innocence Projects have not been directly involved.
All right, Jerry, it's always a great pleasure. We salute the fantastic work you are doing, and you take care, my friend. Thanks for spending time with us.
All right, thanks. Good seeing you again.
Cheers.
Bye-bye.
Bye-bye.